Tort is an unlawful violation of private right, not created by contract, and which gives rise to an action for damages. It is an act or omission producing an injury to another without any previous existing lawful relation of which the said act or omission may be said to be a natural outgrowth or incident. Example: an unborn child is not entitled to damages, but the bereaved parent may be entitled to damages on damages inflicted directly upon them. Gallus versus CA. Defendants in tort cases can either be natural or artificial being. Corporations are civilly liable in the same manner as natural persons. Any person who has been injured by reason of a tortuous conduct can sue the tortfeasor. The primary purpose of a tort action is to provide compensation to a person who was injured by the tortuous conduct of the defendant. Preventive remedy is available in some cases. The backbone of the Philippine tort law is Article 2176, which states that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. Usual tort situation: Cindy was driving while she was texting Maureen. Because she was distracted, she didn't see that Jenica was crossing the street. Cindy bumped Jenica, causing the latter injuries, which made Jenica look uglier than she already is. Driving while texting: this is considered as negligence per se. So the question is, in this example, what is the obligation of law? Is the context of Article 2176, does the motorist have the obligation to be careful in operating a vehicle? Is that the obligation under Article 2176? Is the obligation in a quasi-delict a personal one, a to do or not to do? Doesn't Cindy have the obligation to be careful under Article 2176? No, but not under Article 2176. It is a natural obligation that exists outside of the law. Principle to remember: regardless of how reckless you are, for as long as you don't cause injury to anyone, you are not liable under Article 2176. Responsibility under 2176 arises only when there is damage done, and normally it would not cover potential or perceived injuries. Actual injury is what the law would recompensate. In relation to Article 2176, the obligation to pay for the damage done, provided that there is damage done in the first place. So the obligation involved in quasi-delicts is a real obligation or an obligation to give, that is to pay for damages done. The Latin word for tort is torcere, meaning to twist, or tortum, which means twisted, wrong, or injustice. Under Black Law's dictionary, a tort is a private or civil wrong or injury, including actions for breaches of contracts in bad faith, for which the court will provide a remedy in the form of an action for damages. So from this definition, we can conclude that 1. It is a private wrong involving private acts and parties. It is not a crime, therefore. Number 2, it is a civil wrong, and the remedies are therefore lodged in the form of civil actions in court. And number 3, it includes breaches of contract in bad faith. And 4th, the remedy is in the form of an action for damages. So is tort law in the Philippines to private acts and private parties? No. For example, the law on human relations, that is part and parcel of the tort law in the Philippines. Republic versus CA. The state and its agents are not immune to the provisions of the law on human relations. It applies equally well to both private and public entities. The government may actually be held liable for a tort. The government is not immune from torts. Under the Civil Code 2189, provinces, cities, and municipalities shall be liable for damages for the death of or injuries suffered by any person by reason of the defective condition of roads, streets, bridges, public buildings, and other public works under their control of supervision. Example, on Article 2189, suppose you fell in a manhole. Article 2180, the state is responsible in like manner when it acts through a special agent, but not when the damage has been caused by the official to whom the task done properly pertains, in which case what is provided in Article 2176 shall be applicable. So what happens when an agent of the state commits a tort? Who can be held liable? The state can be held liable vicariously, and that is in Article 2180. Therefore, a tort action is available to a private individual against the state. So how about the reverse? Is the reverse true? Can a tort action be availed of by the state against a private individual? Yes. We consider the following provisions in human relations. Article 24. In all contractual, property, or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. So the court seeks to level the playing field. Article 25, sanctuary legislation in the Philippines. Thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. So the question is tort in the Philippines a purely civil wrong, and the remedies are therefore lodged in the form of civil actions in court? The answer is no. For example, we recall that nuisance is part and parcel of Philippines tort law under the provisions of the Civil Code on nuisance. So we have Civil Code 699, Article 699. The remedies against a public nuisance are 1. A prosecution under the Penal Code or any local ordinance, or 2. A civil action. 3. Abatement without judicial proceedings. Does Philippine tort law include breaches of contract? Well, basing on Article 2176, basing on the code law, then the answer would be no. What does Article 2176 state? There should be no pre-existing contractual relations between the parties. Under Article 2176, a tort or quasi-delict should not include breaches of contract. If there is a pre-existing contractual relation, the remedies should be limited to those provided for breach of contract, such as rescission or specific performance with an action for damages in either case. Example, you rode a bus, after which the bus got into an accident and you weren't able to arrive to your destination safely and securely. You were injured. Do you file an action for damages based on Article 2176? No, because there is a pre-existing contractual relation, which is the breach of the contract of carriage. You must file a case for breach of contract of carriage, now a culpa contractual. However, it is possible that an action for damages based on Article 2176 tort law be filed. The Supreme Court in the precedent case of Loadmasters versus Glodell, the act that breaks the contract may also be a tort. In fine, a tort may arise from a contract whereby tort is not what gave rise to the breach of the contract. Generally, a tort doesn't arise if there is a contractual relation. However, if the act that breaks the contract is also a tort, then you can claim for damages under Article 2176. Air France versus Carrasco. Facts. Plaintiff was a member of a group of 48 Filipino pilgrims that left Manila for Lourdes in France. Air France, through its authorized agent Philippine Airlines, issued to plaintiff a first-class round-trip airplane ticket from Manila to Rome. From Manila to Bangkok, plaintiff traveled in first class, but at Bangkok, the manager of Air France forced him to vacate the first-class seat because, in the words of the witness Cuento, there was a white man who the manager allegedly to have a better right to the seat. When asked to vacate his first-class seat, the plaintiff, as was to be expected, initially refused. But to avoid further commotion, the plaintiff reluctantly gave up his first-class seat in the plane. Hell, the Supreme Court awarded damages to Carrasco based on a quasi-delict, on culpa contractual. There exists a contract of carriage between Air France and Carrasco. First, that there was a contract to furnish plaintiff a first-class passage covering, amongst other, the Bangkok-Tehran leg. Second, that said contract was breached when petitioner failed to furnish first-class transportation at Bangkok. And third, that there was bad faith when petitioner's employee compelled Carrascoso to leave his first-class accommodation berth after he was already seated and to take a seat in the tourist class, by reason of which he suffered inconvenience, embarrassment, and humiliations, thereby causing him mental anguish, serious anxiety, wounded feelings, and social humiliation, resulting in moral damages. On culpa aquiliana, or quasi-delict or tort, even though there is a contract of carriage, there is also a tortious act based on culpa aquiliana. Passengers do not contract merely for transportation. They have a right to be treated by the carrier's employees with kindness, respect, courtesy, and due consideration. They are entitled to be protected against personal misconduct, injurious language, indignities, and abuse from such employees. So it is that any rule or discourteous conduct on the part of employees toward a passenger gives the latter an action for damages against the carrier. The stress of Carrascoso's action, as we have said, is placed upon his wrongful expulsion. This is a violation of public duty by the petitioner air carrier, a case of quasi-delict. Although the relation of passenger and carrier is contractual, both in origin and nature, nevertheless the act that breaks the contract may be also a tort. Tort is not capable of exact definition because the lines are blurred. A tort may overlap from civil actions to criminal actions. As previously noted, an act that breaches a contract may also be a tort. In the same vein, a tortious act may also be classified as a crime. Torts and crimes are different classes of wrongs. Under tort, it is against a private person, prosecuted by the persons themselves. It covers negligent act in general and intentional acts by exception. Remedies are punitive and injunctive in nature, and it only needs a preponderance of evidence. Under crime, it is against the public, prosecuted by the state, covers intentional acts in general and negligent acts as exception. Article 365. Reliefs are mainly prosecutorial, and we need proof beyond reasonable doubt, actus reus and mens rea. The same act may also constitute both a tort and a crime. Example, Noy Noy was driving his car at night above the speed limit while texting Mar. He bumped Jejo Mar as he didn't see him crossing the street. Noy Noy defended that Jejo Mar, with his complexion, could not be seen at night. Remedies of Jejo Mar: criminal prosecution under Article 365 of the RPC, or action for damages under Article 2176 of the Civil Code. Example, in a heated public quarrel, Noy Noy called Jejo Mar Nog Nog, king of the dwarfs. Remedies of Jejo Mar: criminal prosecution under Article 358 of the RPC, imputation of a vice or defect, or action for damages under Article 26 of the Civil Code, vexing or humiliating another on account of his lowly station in life, physical defect, or other personal condition. Therefore, The remedies are not exclusive. You cannot box it up to just civil wrong, because remedies can also extend to those which are not civil wrong, but penal in nature. Definition of tort. Tort is the term applied to a miscellaneous and more or less unconnected group of civil wrongs other than breach of contract, for which a court of law will afford a remedy in the form of an action for damages. The law of tort is concerned with the compensation of losses suffered by private individuals in their legally protected interests through conduct of others, which is regarded as socially unreasonable. So, if it does not fall under a crime or a breach of contract, then it can be a tort. Coverage of Philippine tort law: intentional acts and accidents or acts deemed tortuous by law. Classes of torts: negligence torts. There is fault or negligence, quasi-delict. Intentional torts: it would depend on the presence of negligence. It deals with intent of a particular actor or defendant that causes damage to the plaintiff. And 3, strict liability torts. Under negligence torts, we have Article 2176. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called a quasi-delict and is governed by the provisions of this chapter. For intentional torts, we have Article 26. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. 1. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. And 3. Intriguing to cause another to be alienated from his friends. 4. Vexing or humiliating another on account of his religious beliefs or lowly status in life, place of birth, physical defect, or other personal condition. In Article 26 of the Civil Code, there is intent, but it is considered as a tort. At the same time, you know that there would be criminal prosecution if it amounts to a criminal offense. Vexing or humiliating another, you can file a criminal case. For slander, it can also be libel, if in writing. Strict liability torts, those that are deemed tortuous by law. This is tort where the law has determined that some activities are so dangerous that an individual engaging in those activities is liable for damages regardless of the intent or negligence resulting therefrom. Examples like maintenance of a fire hazard, RA 9513. If you maintain a fire hazard, even if you don't maintain it intentionally, but it is a hazard, then you can be held liable. It is a strict tort liability. RA 2183. The possessor of an animal or whoever may make use of the same is responsible for the damage which it may cause, although it may escape or be lost. This responsibility shall cease only in case the damage should come from force majeure or from the fault of the person who has suffered damage. Example: you are the one held responsible for taking care of my carabao. Consequently, the carabao got away and skewered another person. Such person was injured. Were you negligent? No. Was there intent on your part? No. But you are still held liable because of strict liability. Another, Article 2187, manufacturers and processors of foodstuffs, drinks, toilet articles, and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumers. Example: you were responsible of manufacturing of the product, but someone died or got sick because of your product. Since it is a strict tort liability, you are still held liable despite the absence of direct contractual liability. Another is Article 2193. The head of a family that lives in a building or a part thereof is responsible for damages caused by things thrown or falling from the same. Example, if a person was walking and a pot fell on his head, the pot came from the second floor of the building where your family is situated. You are the head of the family. Even if it wasn't your fault, if you are the head of the family, then you shall be held liable. You are liable by the very fact that you are the head of a family. Negligence is immaterial, strict liability tort. In negligence torts, if you're unable to prove negligence, no liability can be attributed to the defendant. While in strict liability torts, the law imposes absolute liability without regard to fault or negligence and therefore obviates the need to prove fault or negligence in court. All you need to prove is how the law is applicable to the factual antecedents of the case. For intentional torts, at the onset, remember that when a wrongful act is committed intentionally, what usually results is not a mere civil wrong, but a criminal offense. Example, President Duterte says to Leila de Lima that she is fat, dumb, and flirt. What will be Duterte's liability for intentionally calling de Lima fat, dumb, and flirt? Well, it depends. If the statement was printed, liability would be under Article 353 of the RPC, under libel. Take note that these acts require the element of publicity, otherwise there is no crime. What if the statements were uttered privately? If that is the case, then the liability would be civil in nature, and for that you apply Article 26 of the Civil Code. Every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute criminal offense, shall produce a cause of action for damages, prevention, and other relief. And number 4, vexing or humiliating another on account of his religious belief, lowly station in life, place of birth, physical defect, or other personal condition. Intentional infliction of mental distress. This example is also applicable to the intentional infliction of mental distress. The gravamen of the tort is not the injury to the plaintiff's reputation, but the harm to the plaintiff's mental and emotional state. In libel, the gist of the action is the injury to the plaintiff's reputation, where reputation is the community's opinion of what the person is. So if the statements were uttered privately, you're not talking about community perception anymore. You're talking about the effect of a statement upon the person upon whom the statements were directed. In intentional infliction of mental distress, the opinion of the community is immaterial to the existence of the action, although the court may consider it in awarding damages. What is material is the disturbance of the mental or emotional state of the plaintiff as the object of the humiliation. What is important is the plaintiff actually suffers mental or emotional distress because he saw the act or read the statement and it alludes to an identifiable group to which he clearly belongs. Negligence torts are the most prevalent tort. It is not a deliberate tort. Rather, negligence torts occur when an individual fails to act as a reasonable person to someone whom he or she owes a duty to. Elements: duty. The person must owe a duty or service to the plaintiff in question. Number 2, breach. The individual who owes the duty must violate the duty or obligation. The breach must be the proximate causation of the damages suffered by the plaintiff. Number 3, damages. An injury then must arise because of that specific obligation. And number 4, causation. The cause of the injury must have been reasonable, foreseeable as a result of the person's negligent actions. So duty, everyone has a duty to exercise due care of all the time. What is due care? It is the amount of care that a reasonable person would exercise under the circumstances. in due regard of the circumstances of the person and of the time and of the place. Under the Civil Code, Article 1173, the fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. When negligence shows bad faith, the provisions of Articles 1171 and 2201, paragraph 2, shall apply. If the law or contract doesn't state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. Reasonable person. A reasonable person is not any real person or even the average person, but an imaginary prudent person who takes the precautions necessary to avoid harming another person or property. The reasonable person is equated to a good father of a family. Reasonableness. Reasonableness is relative. The element of due care depends on the nature of the obligation and corresponds with the circumstances of persons, time, and place. What is the standard of care required of a bus driver? It depends. Towards his passenger, circumstance of persons, he is bound to observe extraordinary diligence to the safety of the passengers transported by him. Towards non-passengers or other motorists, circumstance of persons, he owes them only ordinary due care. Circumstance of time. A public utility company, such as an electric company, is required to exercise only ordinary care in its day-to-day dealings with consumers. In Elko versus CA, the Supreme Court held that in times of calamities, extraordinary diligence requires the supplier of electricity to be in constant vigil to prevent or avoid any probable incident that may imperil life or limb. There is a change according to time. Circumstances of place. A motorist can operate a vehicle at a high speed at straightaway portion of the road, but must slow down when he approaches an intersection. Years of Completo versus Albaida, July 6, 2010. How about bridge? It is the simplest of the four elements. You must determine whether the defendant followed that standard of care as required. Example, the standard of care required of an owner of an aggressive dog is to keep the dog on a leash. If the owner doesn't do so, then he has breached his duty of care. And how about causation? The cause and effect relationship, causal relationship between conduct and result. There are two types of causation. We have one, the causation in fact. The question is, but for the defendant's action, would injury have occurred? Example, Manny hit Jinky's face with a basketball. Jinky's face would not have been injured if Manny had not hit her in the face with a basketball. Number two, the proximate causation. It's a little bit more complex. Proximate cause is that cause which, in the natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury and without which the result would not have occurred. In other words, even if an event is a cause in fact, it may be not the cause in law. Bataclan versus Medina. Or we have one, Colalas versus CA. Example 1. Practice makes perfect. In order to put up a credible showing in the PBA as 11th overall pick in the 2019 PBA draft, Manny keeps on practicing his dribbling skills in his living room. One time, the ball slips from his hands and hits Jinky's sister Janet in the face, causing a black eye. Was there causation in fact? Was there proximate causation? Yes to both questions. Janet's eye would not have been injured, but for Manny's ball hitting his face, there is causation in fact. As to proximate cause, the ball, in the natural and continuous sequence, unbroken by any efficient intervening cause, found its way to Janet's face, thereby producing the injury and without which the result would not have occurred. Example 2. A week after the incident, Manny once again practiced dribbling in his living room. Once again, the ball slipped from his hands through the window, hitting the ladder set up by the signal TV guy who was installing a satellite dish, causing the ladder to fall and break his arms. Was there a causation in fact? Was there proximate cause? Yes to both questions. Signal guy's arms would not have been broken had Manny's ball not hit the ladder he was using, causing him to fall. There is causation in fact. As to proximate cause, the ball, in the natural and continuous sequence, unbroken by any efficient intervening cause, found its way to the ladder, causing signal guy to fall and thereby break his arms, and without which the result would not have been occurred. Example 3. The next day, undeterred, Manny practiced his dribbling skills some more. This time, when the ball slipped, it hits his neighbor in the head, just as he is pouring gas into his grill. He pours too much, which causes an explosion. In addition to his head injuries, he suffers burns from the explosion and there is some fire damage in the house. Was there a causation in fact? Was there proximate causation? What if the wind caused the fire to spread to other houses and burn down one block in Forbes Park where Manny lives? Let's look at the element of foreseeability. You dribbling while your sister's twin is right there, Manny's wife's sister, and the reference to the first example, you hit her in the face, causing a black eye. Foreseeable when you started dribbling? Yes, maybe. In the second example, there is a guy there installing a satellite dish right outside the window, and the window is open. Would it be foreseeable that your ball will go out of the window and hit him and cause him to fall? Possible. There's an element of foreseeability, although it's kind of remote. But this third example is a difficult situation, something that you cannot really foresee. While you were dribbling, it is foreseeable that it will hit your neighbor just as he was about to put some gas in his grill, which would cause him to pour too much, which would then cause an explosion, and which would then cause injuries to his head, and then fire damage to his house. Foreseeable? No. In this scenario, there is causation in fact. However, proximate cause may be more difficult. Perhaps there is something wrong with the grill or the gasoline that caused the fire. Why was the neighbor pouring gas in the first place? Perhaps one could foresee the neighbor burning himself at the grill, but could the fire damage to the house be foreseen? What about the wind spreading the fire to the other houses? Is this not an efficient intervening cause? Resolution would depend on the evidence, arguments of the counsel, and similar factors, but remember there is no policy under the law curtailing a person from dribbling a ball inside his own house. In the fourth damage, the principle of damnum absque injuria, damage without legal injury. There might be damage, but the law doesn't give you a relief for damages. All injuries can be reduced to monetary amount. The real difficulty comes in the calculating of the damages. For example, it is pretty easy to figure out how much a burnt down house is worth, but it is not easy to figure out how much Janet's eyesight is worth. There's a difficulty in calculating damages because you cannot quantify a certain thing. Now going back to the proximate cause, let's have Calalas versus Court of Appeals 332 Squad 356. Facts. Private respondent Elisa Sunga, then freshman at Silliman University, took a passenger jeepney owned and operated by petitioner Vicente Calalas. As the jeepney was filled to capacity, Sunga was given by the conductor an extension seat, a wooden stool at the back of the door, at the rear end of the vehicle. When the jeepney stopped to let a passenger off and Sunga was about to give way to the outgoing passenger, an Isuzu truck, driven by Verena and owned by Salva, bumped the left rear portion of the jeepney. Sunga sustained multiple injuries and remained on a cast for 3 months. Sunga filed a complaint for damages against Calalas for breach of contract of carriage. Calalas, on the other hand, filed a third-party complaint against Francisco Salva, the owner of the truck. The lower court rendered judgment against Salva and absolved Calalas of liability. It took cognizance of other case, civil case 3490 filed by Calalas against Salva and Verena for quasi-delict, in which Branch 37 of the same court held Salva and his driver, Verena, jointly liable to Calalas for the damage to his jeepney. The CA reversed the lower court's ruling on the ground that Sunga's cause of action was based on a contract of carriage, not quasi-delict, and that the common carrier failed to exercise the diligence required under the Civil Code. The appellate court dismissed the third-party complaint against Salva and adjudged Calalas liable for damages to Sunga. Held. In quasi-delict, the negligence or fault should be clearly established because it is the basis of the action, whereas in breach of contract, the action can be prosecuted merely by proving the existence of the contract and the fact that the obligor, in this case, the common carrier, failed to transport his passenger safely to his destination. In case of death or injuries to passengers, Article 1756 of the Civil Code provides that common carriers are presumed to have been at fault or have acted negligently unless they prove that they observe extraordinary diligence as defined in Articles 733 and 1755 of the Civil Code. This provision necessarily shifts to the common carrier that burden of proof. It is immaterial that the proximate cause of the collision between the jeepney and the truck was the negligence of the truck driver. The doctrine of proximate cause is applicable only in action for quasi-delict, not in actions involving breach of contract. The doctrine is a device for imputing liability to a person where there is no relation between him and another party. In such a case, the obligation is created by law itself. But where there is a pre-existing contractual relation between parties, it is the parties themselves who create the obligation, and the function of the law is merely to regulate the relation thus created. Tort law covers physical and non-physical injuries. Can moral damages be awarded for both physical and non-physical injuries? Yes, it is allowed. For example, moral damages can end physical suffering and non-physical suffering. The purpose of moral damages is to restore you from your spiritual status quo, money to be given in order for you to forget your suffering. Application to physical suffering. If you were in an accident and you lost your hand, can you be awarded moral damage? Yes, because clearly you have suffered mental and physical suffering. Restoration here can only be spiritual. It gives you means and diversions in order for you to forget that you lost your hand. Therefore, there is a difference between physical and non-physical injuries. Aim or theory of tort law. In the aims of the law of torts, Glanville-Williams saw 4 possible bases on which different torts rested. One is appeasement, to restore the claimant to his spiritual, not necessarily physical status quo ante, to appease. That would be your talio, your retribution, rather than exacting proportionality or reciprocity. Physical restoration, if your car will be bombed and they will fix your car. Spiritual restoration, if you bump someone, it led to the amputation of his arm, you pay him damages for spiritual appeasement, because maybe he will forget that he no longer has an arm if you give him a lot of money. It gives him means, methods, amusement to forget. Number 2, justice or vindication, to bring relief to the distress, disturbance, or damage suffered by the claimant caused by the wrong committed by the tortfeasor. Number 3, deterrence, to set an example for the public good so that similar tortious conduct will be avoided. Like, example, you know for a fact that your neighbor is a reckless driver and he was brought to court and was made to pay 1 million in the form of damages. If that's the case, then maybe I should be careful in driving so that I won't be made to pay 1 million like my neighbor. Number 4, compensation, to compensate the plaintiff for unreasonable harms they have sustained. Quasi-delict versus torts. Quasi-delicts are limited to those under Article 2176 to 2194 of the Civil Code. A quasi-delict is strictly a concept of civil law. As defined and originally conceived under Article 2176, a quasi-delict arises only if there is fault or negligence, while torts include quasi-delicts, violations of the law on human relations, and nuisances. A tort originally is a common law concept. Tort is broader than quasi-delict because it includes not only negligence but intentional criminal acts as well. So what are the elements necessary to establish a quasi-delict? We have the case of De Lana versus Byong, 2013 case. On March 2000, Juan de la Lana was driving along Quezon. His sister, Doctora de la Lana, was seated at the front passenger seat. Juan stopped the car across the Veterans Memorial Hospital when the signal light turned red. A few seconds after the car halted, a dump truck containing gravel and sand suddenly rammed the car's rear end, violently pushing the car forward. Due to the impact, the car's rear end collapsed, and its rear windshield was shattered. Glass splinters flew, puncturing Doctora de la Lana. Apart from these minor wounds, Doctora de la Lana did not appear to have suffered from any other visible physical injuries. The traffic investigation report identified the truck driver as Joel Primero. It stated that Joel was recklessly imprudent in driving the truck. Later, Joel revealed that his employer was respondent Rebecca Byong. As the days passed by, Doctora de la Lana suffered from a whiplash injury. Dr. Mila required her to undergo physical therapy to alleviate her condition. Dr. de la Lana's condition did not improve despite 3 months of extensive physical therapy. Dr. Flores, a neurosurgeon, finally suggested that she undergo a cervical spine surgery to release the compression of her nerve. On October 19, 2000, Dr. Flores operated on her spine and neck between the C5 and the C6 vertebrae. Dr. de la Lana on October 16, 2000 demanded from Rebecca compensation for her injuries, but Rebecca refused to pay. Hence the case. The Ortiz ruled in favor of Dr. de la Lana and held that the proximate cause of Dr. de la Lana's whiplash injury to be Joel's reckless driving, but see a reversed RTC ruling. And the issue is whether Joel's reckless driving is the proximate cause of Dr. de la Lana's whiplash injury. Held, there are 3 elements. Damage, de la Lana suffered whiplash injuries. How about negligence? Driver of the dump truck was driving recklessly. Third element is relation of cause and effect between the two. The chain of causation between the reckless driving and her whiplash injury. What is the duty of the plaintiff? To first establish by preponderance of evidence that the 3 elements of quasi-delict exist. Did the plaintiff succeed in the instant case? No. She failed to discharge the burden of proving the 3rd element of quasi-delict. She failed to establish by preponderance of evidence that the driver's negligence in its natural and continuous sequence, unbroken by any efficient intervening cause, produced her whiplash injury, and without which her whiplash injury would not have occurred. Remember, we have discussed that there are 2 types of causation: causation in fact and proximate causation, or causation in law. Causation in fact does not really refer to our own law on tort, Article 2176. What we are concerned here is that there should be a causal connection between the negligent act of the defendant and the damages or injuries suffered by the plaintiff. So that is the definition of proximate cause. The cause which, in the natural and continuous sequence, unbroken by any efficient intervening cause, suffices to produce the injury, and without which the injury would not have occurred. So what was the evidence of de la Lana here? 1. The picture for damaged car. According to the Supreme Court, it only proves impact. It cannot be used to infer whiplash injury. Number 2. The medical certificate dated November 2000, hearsay. The doctor who issued it did not testify. Number 3. Her testimonial evidence that collision can cause whiplash injury, excluded for being a mere opinion. The only opinion that matters is the opinion of the court. Negligence is defined under Article 1173. The fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Smith-Bell v. Borja, 2001. Negligence is conduct that creates undue risk of harm to another. It is the failure to observe that degree of care, precaution, and vigilance that the circumstances justly demand, whereby that other person suffers injury. And there are two types of fault. Fault substantive and independent, which on account of its origin gives rise to an obligation between two persons not similarly bound by any other obligation, otherwise known as culpa aquiliana or culpa extracontractual. These are faults or negligence and culpa contractual, fault that exists concurrent with a pre-existing obligation. Also, a violation of penal law. Fault substantive and independent of contract. Cause, if there is a contract, you do not call that quasi-delict. You call that culpa contractual or breach of contract. And the origin of culpa aquiliana is lex aquilia from Roman law. If anyone wrongfully kills another, male or female, slave or four-footed herd animal, let him be ordered to pay the owner whatever its highest value was in the preceding year. Fault that is not criminal, fault that is not contractual in nature. Note that this is a mere civil action despite the fact that it may concern the unlawful killing of a person or slave. The killing of a slave then was not treated as a crime, it was merely a tort. But that was the Roman law. Number 2, as an incident in the performance of an obligation which already existed, which cannot be presumed to exist without the other, and which increases the liability arising from the already existing obligation. This means that the fault or negligence arises out of a pre-existing obligation. There can be no liability if there was no contract in the first place, also known as culpa contractual. Example, A is not contractually bound by B, and A is negligent and B is injured. That is a culpa aquiliana. Another example is Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So do you know the contract of comodatum? Delivery perfects the contract of comodatum. Remember that the ultimate obligation is to return, but in the meantime, you have the obligation to take care of it. What if you borrowed a pen and you lost it? That is culpa aquiliana? No, it is culpa contractual. Fault under 2176 is fault substantive and independent. It means that Article 2176 is an independent source of obligation. Fault in Article 2176 cannot be an incident in the performance of an obligation because the provision requires that there should be no pre-existing contractual relation between the parties. Article 1173, the fault or negligence of the obligor consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons, of the time, and of the place. Is there a uniform rule in the determination of whether or not a person is negligent? No. In Corliss versus Manila Railroad Company, the Supreme Court ruled that negligence is want of care required by the circumstances. It is relative or comparative, not an absolute term, and its application depends upon the situation of the parties and the degree of care and vigilance which the circumstances reasonably require. Where the danger is great, a high degree of care is necessary, and the failure to observe it is a want of ordinary care under the circumstances. Relative, not absolute. Example, driving in a crowded street during business hours compared to driving in an empty street. Number 2, transporting an infant compared to transporting an adult. Number 3, carrying a loaded gun compared to carrying an empty one. The relative positions and physical situations of the parties must also be considered. It means that the negligence is relative, not absolute, and you have to consider the relative positions and physical situations of the parties. This is what they call the Spider-Man doctrine. Because with great power comes great responsibility. So the greater your position, the more careful you should be. 2010 case, Years of Completo versus Albaida. On August 27, 1997, while Albaida was on his way to the office to report for duty, riding a bicycle along 11th Street, the taxi driven by Completo bumped and sideswiped him, causing serious physical injuries. Albaida was brought to the Philippine Air Force General Hospital inside VAB. However, he was immediately transferred to the Armed Forces of the Philippines Medical Center because there was a fracture in his left knee and there was no orthopedic doctor available at PAFGH. Ruling, it is a rule in negligence suits that plaintiff has the burden of proving by the preponderance of evidence the motorist's breach in his duty to care owed to the plaintiff, that the motorist was negligent in failing to exercise the diligence required to avoid injury to the plaintiff, and that such negligence was the proximate cause of the injury suffered. It is obvious that a motor vehicle possesses a greater danger of harm to a bicycle than vice versa. Accordingly, while the duty of using reasonable care falls alike on a motorist and a bicyclist, due to the inherent differences in the two vehicles, more care is required from the motorist to fully discharge the duty than from the bicyclist. The physical advantages that the motor vehicle has over the bicycle make it more dangerous to the bicyclist than vice versa. Compare a taxi with a bicycle, which is easier to operate, the bicycle. But taking into consideration their position, do bicycles have the same right on the road compared to taxis? According to the Supreme Court, yes, because they occupy the road, the same right with other vehicles. Does the term quasi-delict apply to intentional acts? Dulay versus CA. Facts, Benigno Terzuela is an employee of Safeguard Investigation and Security, or Superguard Security Company, at the time of the incident complained of, was under the control and supervision. So on December 7, 1988, an altercation between Terzuela and attorney Napoleon Dulay occurred at the Big Bang at Alabang village, as a result of which Terzuela, the security guard on duty at the said carnival, shot and killed Dulay. Action for damages was filed against Terzuela and Safeguard or Superguard, alleged employers of defendant Terzuela. Ruling, Article 2176 covers not only acts committed with negligence, but also acts which are voluntary and intentional. In criminal law, what happens if the security guard kills in the line of duty? Can you sue the company criminally? No. But there could be civil liability when the employee's criminal guilt becomes the employer's civil guilt, when the employer becomes subsidiarily liable, when the employee is insolvent. There are three different types of culpa that can be used as basis for personal injury actions, namely culpa aquiliana, culpa contractual, and culpa criminal. Under culpa aquiliana, there can be a quasi-delict as long as there is fault or negligence resulting in damage or injury to another. It is broader in scope than crime. Criminal intent is not necessary for quasi-delict to exist. Fault or negligence without intent will suffice. Right violated is a private right. Quasi-delict is a wrongful act against a private individual. Every quasi-delict gives rise to a liability for damages, preponderance of evidence, and reparation or indemnification of the injury or damage, direct, substantive, and independent. Rakes versus Atlantic. Complete and proper defense insofar as parents, guardians, employees are concerned. Article 2180, last paragraph. No presumption of negligence. The injured party must prove the negligence of the defendant, like Kanko versus MRC. Otherwise, the complaint of injured party will be dismissed. Under culpa criminal, there can be no crime unless there is a law clearly punishing the act. Criminal intent is essentially for criminal liability to exist. Right violated is a public one. Crime is a wrong against the state. Some crimes do not give rise to liability. Example, illegal possession of firearm. Contempt. Proof beyond reasonable doubt. Punishment is either imprisonment, fine, or both. Sometimes other accessory penalties are imposed. Under culpa contractual, while negligence is merely incidental to the performance of the contractual obligation, there is a pre-existing contract or obligation, not a complete and proper defense in the selection and supervision of employees. The same case, Kanko versus MRC. There is presumption of negligence as long as it can be proved that there was breach of the contract. The defendant must prove there was no negligence in the carrying out of the terms of the contract. Same case. Case of Kanko versus Manila. Facts. Plaintiff Jose Kanko, an employee of Manila Railroad Company, was taking his daily train ride to the company's office in Manila on January 20, 1915. As the train slowed down, Kanko stepped off, but one or both his feet slipped on a sack of watermelons on the station's platform. Kanko's body rolled from the platform and was drawn under the moving car, where his right arm was crushed. The accident occurred between 7 and 8 p.m., and since the station was dimly lit by a single light, objects on the platform were difficult to see. On the other hand, the sack was placed along with others on the platform as a shipment to the market. Kanko then instituted a proceeding to recover damages in the Court of First Instance of Manila, finding his action on the negligence of Manila Railroad's employees in placing the sacks of platform. However, the judge ruled that Kanko failed to use due caution in alighting from the train. Issue: whether or not defendant Manila Railroad Company is liable for damages? Yes. Number 2, whether plaintiff Kanko is liable for contributory negligence? No. Doctrines used. Article 2176 Civil Code: whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called quasi-delict. Number 2, Article 2180, number 158 of the Civil Code. The obligation imposed by Article 2176 is demandable not only for one's own act or omission, but also for those of persons for whom one is responsible. Employers shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned task, even though the former are not engaged in any business or industry. The responsibility treated of in this article shall cease when the persons herein mentioned prove that they observe all the diligence of a good father of a family to prevent damage. The source. Extra contractual obligations have their source in those mutual duties which civilized society imposes upon its members, the breach of which gives rise to an obligation to indemnify the injured party. As such, in case of culpa aquiliana, it is the wrongful or negligent act or omission that creates the vinculum juris, whereas in contractual relations, the vinculum exists independently of the breach. Burden of proof. In culpa aquiliana, where the plaintiff cause of action depends on a negligent act or omission, the burden of proof rests upon the plaintiff to prove negligence. On the other hand, since an obligation already exists in culpa contractual, mere proof of the contract and of its non-performance are sufficient prima facie for recovery. Defense of employer for negligence of employee. The presumption of negligence in Article 1903 is rebuttable. and the employer is relieved of liability upon proof that he has exercised due diligence in the selection and supervision of employees. However, the same does not apply in culpa contractual. The court also describes the fields of contractual and non-contractual obligations as concentric. That is to say, the fact that a person is bound to another by contract does not relieve him from extra contractual liability to the latter. On the liability of defendant Manila Railroad to plaintiff Kanko, the foundation of defendant's liability is its contract of carriage with plaintiff, which carries by implication the duty to carry him safely and provide safe means of entering and leaving its trains. Thus, non-performance of the contract could not be excused by proof that the fault was imputable to defendant's employees. On plaintiff's lack of contributory negligence, Thompson defines the test to determine whether a passenger alighting from a moving train is guilty of negligence as that of ordinary or reasonable care. In this instant case, not only was the station dimly lit and the train barely moving, but plaintiff is a fit young man for whom alighting a moving train would not be risky. So decision is reversed. Again, negligence must be proved in a suit on a quasi-delict, so that the plaintiff may recover. Note as well that the plaintiff must establish negligence by preponderance of evidence. However, since negligence in some cases is hard to prove, we apply the doctrine of res ipsa loquitur. This means that in certain instances, the presence of facts and circumstances surrounding the injury clearly indicate negligence on the part of the defendant. The maxim applies whenever it is so improbably that such accident would have happened without the fault of the defendant, that a reasonable man could find without further evidence that it was so caused. The maxim throws on to the defendant the burden of disproving negligence. The facts and circumstances of the case need to no other conclusion that defendant was negligent. There is no other explanation to it. The defendant is negligent. Ordinarily, he who charges negligence shall prove it. However, res ipsa loquitur is the exception because the burden of proof is shifted to the party charged of negligence, as the latter is the one who had exclusive control of the thing that caused the injury complained of. The requisites for the application of the res ipsa loquitur rule are the following. 1. The accident was of a kind which does not ordinarily occur unless someone is negligent. 2. The instrumentality or agency which caused the injury was under the exclusive control of the person charged with negligence. And 3. The injury suffered must not have been due to any voluntary action or contribution on the part of the person injured. Garcia versus People. The doctrine of res ipsa loquitur as a rule of evidence is unusual to the law of negligence, which recognizes that prima facie negligence may be established without direct proof and furnishes a substitute for specific proof of negligence. The doctrine, however, is not a rule of substantive law, but merely a mode of proof or a mere procedural convenience. The rule, when applicable to the facts and circumstances of a given case, is not meant to and does not dispense with the requirement of proof of culpable negligence on the party charged. It merely determines and regulates what shall be prima facie evidence thereof, and helps the plaintiff in proving a breach of the duty. The doctrine can be invoked when and only when, under the circumstances involved, direct evidence is absent and not readily available. Illustration of culpa aquiliana, culpa contractual, and culpa criminal. Example number 1. Let us suppose that if a common carrier leaves a passenger stranded in the middle of nowhere, there is a breach of contract of carriage. Remember, the obligation of a common carrier to bring the passenger safely and securely to his contracted destination. It does not matter how the contract is breached or whether in the breach of contract the common carrier was negligent. The fact that the contract was entered into and was not fulfilled is enough for culpa contractual to be a source of liability. That is what culpa contractual is all about, breach of contract. Example number 2. You rode a bus operated by Y Bus Company. The driver of the bus was negligent and bumped a light post. You did not arrive at your destination safely and securely. You also suffered injury. What type of culpa is involved in that situation? That is culpa contractual because there is a breach of contract of carriage. But remember, there is negligence on the part of the driver. Can you, for example, sue the bus company for culpa acquiliana? As a general rule, you cannot because there is a pre-existing contractual relationship. There must be no pre-existing contractual relation between the plaintiff and the defendant for you to maintain an action for damages under Article 2176. But there is a very broad exception based on jurisprudence, as held in Air France versus Carrascosa. It has been held many times by the Supreme Court that if the manner of breaching a contract is in itself tortious, there can be a viable cause of action for culpa acquiliana, even there is a pre-existing contractual relationship between the parties. What are defenses in quasi-daily cases? 1. The defendant was not negligent. Under this defense, the defendant tries to attack the elements of quasi-delict, that is, the element of negligence. The defendant is saying, I was not negligent, I was being careful. The defendant, therefore, when he interposes the type of defense, he is trying to prove before the court that a preponderance of evidence exists that he exercised the required degree of care that corresponds with the circumstances of the time, the person, and the place. Number 2. Damnum absque injuria. This simply means damage without wrong, or damage without anything that the law considers a legal injury, one that at least is compensable under the law. Examples under the concept of justifying circumstances in the RPC, there can be damnum absque injuria. Briefly, they appear in Article 11 as follows. Self-defense. B. Defense of relatives. C. Defense of strangers. D. State of necessity. E. Fulfillment of a duty or exercise of a right of office. And F. Obedience of lawful orders. Article 429 of the Civil Code is another instance where there may be damage or injury, but there is no liability. Article 429. The owner or lawful possessor of a thing has the right to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Simply put, liability only arises if there is an invasion of a right that corresponds with a breach of duty, meaning when you committed the injury, you have no right whatsoever to cause that injury. The third defense is that the plaintiff's own negligence is the proximate cause of the loss. Article 2179. When the plaintiff's own negligence was the immediate and proximate cause of his injury, he cannot recover damages. This is a complete defense directed particularly to the element of causation, or that there must be a causal connection between the fault or negligence and the damage. Number 4. Prescription. What is the prescriptive period for filing an action based on quasi-delict? Article 1146. The following actions must be instituted within 4 years. 1. Upon an injury to the rights of the plaintiff. 2. Upon a quasi-delict. What is the difference between number 1, upon an injury to the rights of the plaintiff, and number 2, upon a quasi-delict? In Valencia v. Cebu Portland Cement, December 23, 1959, the plaintiff was separated from employment for allegedly unjustifiable cause. Supreme Court held that the action is one for injury to the rights of the plaintiff. Valencia was decided before the effectivity of the Labor Code in 1974. During that time, labor complaints were cognizable by judiciary. Right now, under the Labor Code, the act complained of in Valencia is cognizable as illegal dismissal. What is the proper prescriptive period? It's still 4 years. But remember the labor principle that a person's right to his labor is a property right. Thus, in proper legal contemplation, illegal dismissal is a violation of a property right or an injury to the rights of the plaintiff. Thus, Valencia still applies. Tikay Shipping versus Concha, February 22, 2012. Number 5 defense is assumption of risk. The doctrine of assumption of risk is to the effect that bears a claim for negligence when it can be shown that the plaintiff, by his or her conduct, voluntarily chose to encounter a known and specific danger and either fully appreciated or should have fully appreciated the risks posed by that conduct. The applicable Latin maxim is violenti non fit injuria or volenti non fit injuria, nices dolus, meaning he who voluntarily assumes a risk does not suffer damage thereby, or to a willing person no injury is done. This doctrine holds that a person who knowingly and willingly puts himself in a dangerous situation cannot sue for any resulting injuries. Again, this is a common law doctrine of Anglo-American origin, which serves as a bar to recovery damages in negligence cases. Number 6, force majeure. Article 1174, except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. This is complete and proper defense for a quasi-delict case, actus de nemini facit injuriam. The act of God prejudices no one. Requisites for force majeure. 1. The cause of the unforeseen and unexpected occurrence or of the failure of the debtor to comply with his obligation must be independent of the human will. Example, a building is destroyed by an earthquake. Typhoon destroys ship and cargo. Number 2, it must be impossible to foresee the event. Or, if it could be foreseen, it must be impossible to avoid. Example, earthquake is impossible to foresee and impossible to avoid. That a typhoon will strike is impossible to foresee and avoid, but see Tan Chong Shan versus In Chaisti. Number 3, the obligor must be free from any participation in the aggravation of the injury resulting to the creditor. And finally, number 7, due diligence in selection and supervision. Article 2180, the obligation imposed by Article 2176 is demandable, not only for one's own acts or omissions, but also for those of persons for whom one is responsible. The father, and in case of his death or incapacity, the mother, are responsible for the damages caused by the minor children who live in their company. Guardians are liable for damages caused by the minors or incapacitated person who are under their authority and live in their company. The owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on occasion of their functions. Employees shall be liable for the damages caused by their employees and household helpers acting within the scope of their assigned tasks, even though the former are not engaged in any business or industry. The state is responsible in like manner when it acts through a special agent, but not when the damage has been caused by the official to whom the task done properly pertains, in which case what is provided in Article 2176 shall be applicable. Lastly, teachers or heads of establishments of arts and trades shall be liable for damages caused by their pupils and students or apprentices, so long as they remain in their custody. The responsibility treated of in this article shall cease when the person herein mentioned prove that they observed all the diligence of a good father of a family to prevent damage.